of Tennessee is now in session.
Good afternoon, everyone. Thank you for agreeing to appear mechanically. We're still doing this for reasons of the COVID virus, but it's worked very well, and I'm sure it'll work well this time. And thank you for participating. As you may know, this is being live streamed, and also it's being recorded, and it will be placed on our website in the near future. Mr. Hivner, would you call the case?
Jeffrey Clay Davis versus Vanderbilt University Medical Center.
Okay. Is the appellant ready?
Yes, Your Honor. Good afternoon. May it please the court. I am Nancy Vincent with the law firm of Vincent and Associates, and I, along with Bob Lynch Jr., am counsel of record in this appeal for plaintiff appellant Jeffrey Davis. In this appeal, on behalf of this...
Did you reserve time already?
Yes, Your Honor.
Oh, okay.
I requested 5 minutes for...
Okay.
Thank you, Your Honor. In this appeal, on behalf of Mr. Davis, we request that this court reverse the trial court's judgment in granting the defendant's motion to dismiss Mr. Davis's amended complaint. The standard of review is de novo with no presumption of correctness. Mr. Davis was employed by Vanderbilt from January 2006 to August 2018 as a claims manager for Vanderbilt Risk and Insurance Management. On June 13, 2019, Mr. Davis filed an amended complaint, including the exhibits attached, in which he alleged that Vanderbilt terminated him for refusing to remain silent about or participate in Vanderbilt's failure to mitigate violent crimes such as assault and battery occurring at Vanderbilt hospitals between Vanderbilt employees, patients, and the unsuspecting public. This complaint includes an express claim for relief under the whistleblower statute that plaintiff refused to remain silent about or participate in Vanderbilt's violation of OSHA's General Duty Clause by failing to maintain safe premises on which significant violence occurred. The allegations in the complaint include that plaintiff was responsible for and had collected data evidencing a significant level of violence on Vanderbilt's premises, including in its hospitals, involving Vanderbilt's employees, patients, and the public in violation of OSHA. Vanderbilt failed and refused to address such violence and instead continued to conceal such violence from Vanderbilt employees, patients, and the public. Vanderbilt sought to limit plaintiff's report or dissemination of information that such violence was occurring at alarming levels in Vanderbilt hospitals by screening his communications with Vanderbilt employees, and the complaint also contains allegations that Vanderbilt ultimately terminated plaintiff for refusing to remain silent about or participating in Vanderbilt's illegal activities, including violating OSHA and misrepresentation by concealment. The complaint also contains allegations that the violence on Vanderbilt's premises endangers life and health, which allegations can be found by the trier of fact to constitute a nuisance, and that Vanderbilt should have been aware of a substantial unjustifiable risk to its employees and the public as a result of this significant violence on its premises, which allegations also can be found by the trier of fact to constitute criminal negligence or some other actionable conduct as it may be established at trial. Notwithstanding these allegations in the complaint, the trial court granted Vanderbilt's motion to dismiss, finding that Vanderbilt's failure to follow OSHA's guidelines was not an illegal activity for purposes of the whistleblower statute, finding that the complaint does not state a claim under the Patient Safety and Quality Improvement Act, and that Vanderbilt was, quote, not engaging in illegal activities when patients assault and batter Vanderbilt employees absent of findings of criminal negligence or some other actionable conduct, end quote. So even though the trial court noted that the allegations in the complaint of assault and battery may support a finding of criminal negligence or other actionable conduct, presumably following discovery, the trial court still dismissed the complaint. Even though the complaint contains in paragraph 12 the allegation that Vanderbilt was illegally failing to comply with OSHA's general duty clause, the trial court still dismissed the complaint. In its dismissal of the complaint, the trial court failed to address that whether, in fact, Vanderbilt's acts were or were not illegal is not dispositive, given that the whistleblower statute protects litigants who have a good faith belief that such a violation existed. In Mason v. Seton, the Supreme Court so held in Mason v. Seton in 1997. In Mason v. Seton, the underlying illegal act was an OSHA violation, code violation for locking doors in the laundry room that posed a safety to
Chancellor Martin suggested that, well, did more than suggest. She said that the regulations or OSHA guidelines that were alleged to be violated did not have to be followed by Vanderbilt. Is that accurate?
Well, that may be accurate, but the complaint includes the allegation in paragraph 12 that specifically that the public policy for which the plaintiff is used to participate in or remain silent about is OSHA's general duty clause. And so the complaint contains other allegations involving the guidelines, but it also stated that he refused to participate or remain silent about violating this particular statute, which is not a guideline, it is a statute. And it goes on to say—
Which one is that, please?
Paragraph 12, Your Honor.
No. Which statute do you say was involved in that? The general duty?
Under the general duty clause, Your Honor, it's footnoted at page, it's footnote 3. And that's the specific provision of OSHA that was alleged to be violated.
So you're no longer claiming that the guidelines have to be followed?
Your Honor, in the complaint, we are alleging that the guidelines form the basis of particularly the general duty, some things that OSHA may require contained in the general duty clause, but the fact is the complaint was dismissed without regard for the allegation that he refused to remain silent about its violation of the general duty clause. At that point in the case, with the first paper being filed in the case, the plaintiff was aware and had a good faith belief that committing this serious assault and battery on the premises in the hospital posed a danger to the workers and the public. And that is all under Webb, the National Habitat for Humanity is required in order to state a claim. In discovery is where we would absolutely find exactly which provisions, additional illegal activities. But at this stage of the game, the plaintiff has alleged that the act, and in addition, Your Honor, since you asked about allegations, in paragraph 23 of the complaint, the plaintiff was concerned that Vanderbilt failed to update its workplace violence policy. And the plaintiff was concerned that, notwithstanding the guidelines or anything else, that that if Vanderbilt got audited, it would be cited by OSHA for its failure to have an updated workplace violence policy. And
Counsel, do you agree with the Vanderbilt's characterization of the general duty clause as imposing two types of duty on the hospital, one being the duty to furnish each of its employees a place of employment which is free from recognized hazards, and then secondly, a duty to comply with occupational safe and healthy standards, health and safety standards and all rules and regulations and orders. Do you agree with that? You do. So which of those two duties specifically do you say that Vanderbilt violated in this instance?
So it is alleged in the complaint that, particularly that they failed to provide their employees with a place of employment that was free from recognizable hazards that are causing or likely to cause death or serious harm to employees. In addition, Your Honor, in paragraph 12, it is alleged in the complaint that that he remained silent about his failure to Vanderbilt's failure to abide by all of OSHA and COSHA regulations. So it's not just limited to the general duty clause. And in the case of Mason,
Now, you've reached your time limit.
okay, thank you, Your Honor.
Thank you.
Good afternoon, Your Honors. This is Bill Rutchow. I represent the appellee, Vanderbilt University Medical Center. Appellant shorthanded it to Vanderbilt. I may do that. I may also refer to it as VUMC. As I'm going through this, that's how my client refers to it. So you may hear me slip back and forth between the two. The focus is on the amended complaint, not the new and expanded allegations that have cropped up in appellant's brief and here in oral argument today. It's what's in the amended complaint, reasonable inferences that can be made from that complaint. And really, repeatedly throughout the complaint, and possibly this is the best example of it, but repeatedly throughout the complaint, appellant is very specific about their allegation. It is not a broad, vague allegation of illegal conduct. It's very specific. It says plaintiff alleges the sole and or substantial motivation for his termination from Vanderbilt was due to retaliation by his supervisor, other persons, because of his failure to remain silent about the violations, deficiencies, and continued efforts to bring Vanderbilt within compliance of the OSHA workplace violence guidelines. That's his allegation of the illegal conduct throughout the complaint. It's the illegal conduct that got him fired, or what got him terminated, refusing to remain silent about Vanderbilt's failure to comply with these OSHA guidelines. This is not, appellant relies heavily on the Webb case. This is almost the reverse of the Webb case. The Webb case involved an inartfully, very broadly pled allegation. This is a very artful, very specific, very detailed complaint that makes a very specific allegation as to what the illegal conduct was. It incorporates numerous lengthy exhibits, and they all make very clear, as highlighted by that paragraph 37 I just read, that the plaintiff was terminated for refusing to remain silent about VUMC's failure to comply with these workplace guidelines. Now, appellant has argued that he also reported illegal activities other than violations of OSHA guidelines, and that his intention was to protect the general public and patients. And what's completely absent from the amended complaint is any allegation that Mr. Davis ever attempted to voice these unvoiced intentions about the general public or patients to Vanderbilt. In other words, Vanderbilt, based on the allegations of the complaint, Vanderbilt could not have terminated Mr. Davis for an unspoken intention that they knew nothing about. Look through all of the exhibits that have been incorporated in the complaint, all of the allegations in the complaint. The concerns that Mr. Davis repeatedly raised were that Vanderbilt was not complying with these workplace safety guidelines. Say it differently, while protecting patients, protecting the general public is certainly a laudable goal, it's not OSHA's goal. Alleging that an employer terminated an employee for refusing to remain silent about the employer's failure to comply with OSHA guidelines that are designed to protect employees in the workplace does not provide notice to the employer that the employee is also alleging that he was terminated for attempting to protect the safety of non-employees, which is exactly what they're arguing here on appeal. The focus is on that fourth element of a TPPA claim, that the defendant terminated the plaintiff's employment solely for the plaintiff's refusal to participate in or remain silent about the illegal activity.
Can you run that, run back through that a little bit slower, please? Because I have a little bit trouble following you about who it is reported to or was not reported to, and the
Sure.
employee and the non-employee.
Right. If you look at the allegations of the complaint and all
Which
of
one?
all of them, it
Okay.
goes throughout all of the complaint. If you look at all of the exhibits to the complaint, the allegations by Mr. Davis are that he reported he refused to remain silent about Vanderbilt's failure to comply with these OSHA workplace guidelines. There's memos and emails that he sends to his supervisor saying, we need to comply with these OSHA guidelines. Nowhere in any of that does he allege that he reported to Vanderbilt, hey, we also need to protect the general public. We also need to protect the patients. It was all focused on the violations of these OSHA guidelines. And so that can't put Vanderbilt on notice that he is claiming that he was also terminated for something he never said. Vanderbilt never got from him. This is based on the complaint. I'm not arguing
What he said to the employees. Wasn't there an allegation about some comments made in a meeting with him?
There absolutely were. The comments in the meeting were related to him informing the employees about these OSHA workplace guidelines. And again, it was conversations back and forth with the employees about workplace safety. This is not allegations about protecting the general public. These are not allegations about protecting patients. There is one allegation.
Didn't he mention something about the Patient Safety and Quality Improvement Act?
He did mention the Patient Safety, Quality, and Improvement Act, and that's nonsensical, Your Honor, because the Patient Safety, Quality, and Improvement Act is a statute that creates a confidentiality and privilege standard for a hospital to designate certain documents as confidential. It doesn't have anything to do with the allegations in this complaint. The only thing it even relates to with regard to this is that it's got patient safety in the name. But it is a confidentiality standard. It's like if I get from a trial court a protective order to protect documents as confidential, and I stamp those documents as confidential. That's what the Patient Safety, Quality, and Improvement Act allows a hospital to do with their internal quality improvement committees. So that's the only reference there ever is in the complaint with regard to patient safety. There is an allegation in paragraph 12 with regard to criminal assaults and battery. But again, all they say is that he intended to protect the general public. There is no allegation that Vanderbilt terminated him for refusing to remain silent about criminal assaults and battery, or that they terminated him for refusing to remain silent about efforts to protect the general public. The only allegations repeated through the complaint are that he was terminated for refusing to remain silent about these OSHA guidelines. That's it. even when he refers to these assaults and batteries, when you look at paragraph 12, there's a referral to paragraph 20. In paragraph 20 of the amended complaint, he references an exhibit G. Both of those, he says that the reason, his purpose in pulling together this listing of workers' comp claims that included assaults, it included virus exposure, needle sticks, it was a list of workers' comp claims. That his purpose in raising that, and this is directly from paragraph 20, was to raise concerns about the high number of workplace violence-related claims which could lead to OSHA sanctions if not remedied. So again, the entire amended complaint, fair reading of the amended complaint is that he is raising a concern about the failure to comply with these OSHA guidelines, not misrepresentation by concealment that doesn't show up anywhere in the complaint, not creating a public nuisance which does not show up anywhere in the complaint, or any of these other new factual allegations that have come out in the briefing.
What about the general duty clause?
Your Honor, I think there's three pieces of the general duty clause. The first one is, again, and I know I'm sounding like a broken record, but if you read the allegations in the amended complaint, although they address the general duty clause from a public policy standpoint, they don't address the general duty clause as the illegal act, the definition of the illegal activity for which he was terminated. Again, going back to that fourth element, never alleges that he was terminated for refusing to remain silent about violations of the general duty clause or OSHA in general. It is violation of these OSHA workplace guidelines. Second part of that is what OSHA itself says about guidelines and the general duty clause. What OSHA says is the fact that OSHA has developed industry-specific guidelines is not evidence of an employer's obligations under the general duty clause. The fact that a measure is recommended in any OSHA guideline document but not adopted by an employer is not evidence of a violation of a general duty clause. And I believe that answers one of the earlier questions to Ms. Vincent about whether or not following guidelines is a violation of the general duty clause. And the answer is it's not a violation of the clause, according to OSHA itself. And I guess the third piece with regard to the general duty clause, Your Honor, is, since I was on the winning side at the trial court, I guess I tend to have a better view of Chancellor Martin's opinion, but I do think she said it well. She said the general duty clause does not set any specific standard. It simply requires compliance with the OSHA Act. Given the narrowness of the TPA's application by the courts as an exception to Tennessee's longstanding public policy, the court will not read such an aspirational and non-specific clause to require adherence to guidelines and recommendations that are not otherwise mandated. I think that answers the question. The first half of the general duty clause that was addressed earlier, the first half is very broad and aspirational. The second one discusses an employer's duty to comply with standards. None of them require an employer to comply in terms of whether they're engaged in an illegal act. Should require them to comply with a non-mandatory guideline that OSHA itself says is not mandatory.
So is your argument that what the concerns that Mr. Davis articulated to management at Vanderbilt, to the employees at Vanderbilt, that Vanderbilt was not adopting or following OSHA regulations, that did not constitute activities that are in violation of the code, civil or criminal of the United States, or any regulation intended to protect the health, public health, safety, or welfare?
It's two parts of that. The first is this was not an OSHA regulation; it was a guideline. OSHA's regulations are set out.
Okay.
Yeah. And then the second part of it is where you ended, which is that OSHA regulations, even if this guideline had been a regulation, OSHA regulations are intended to protect employees in the workplace. It's workplace
So wait a
safety,
minute,
not public safety.
so are you saying there that once you become an employee, then public health is not in play? It's, what is it, private health in play or what?
No,
not in play at all.
it is the express reach of the statute and the regulations that Mr. Davis was alleging, which are OSHA regulations, which the OSHA statute says that its purpose is to protect the workplace. And there are several Tennessee
And
cases.
is that not a protection of the public health?
No, and cases of this court have found that it's not a protection of the public health, that protection of workplace is narrower and different than protection of the public, and that the Tennessee Public Protection Act requires a regulation that is intended to protect the public health, and that protecting the workplace is not the same thing.
Okay. Thank you.
Thank you. And Your Honors, that is all I have. I will yield the remainder of my time.
Thank you very much. Ms. Vincent.
Yes, Your Honor. This is at the stage of the motion to dismiss based upon whether the allegations in the complaint make out a claim under any theory. There is a lot of focus on the allegations in the complaint that relate to the guidelines, but the standard clarified by the Tennessee Supreme Court in 2011 in the Webb case makes it clear. A motion to dismiss may not be granted when the allegations in a complaint state a claim under any theory.
Well,
And
it also says that would entitle the plaintiff to relief. And so we got to look at that part of it too. So, I mean, yeah.
Yes, Your Honor. In Mason v. Seaton, that's a 1997 case that the Tennessee Supreme Court decided. It was an OSHA case. The only complaint made by the plaintiffs there was that they reported that the defendant hotel locked the doors, which was unsafe and they felt like were illegal acts. It wasn't until the discovery phase and an expert testified that such a violation, if the defendant hotel had been permitted to go through with locking both doors, could have constituted an OSHA violation. It's not at the stage of pleading where all of the claims, all of the violations have to be laid out. It's the only thing in Webb v. Campbell, the Supreme Court again said where the plaintiff alleges that the employer terminated her for not remaining silent about discriminatory illegal practices, that was sufficient. In this case, in the complaint, our client alleges that he was terminated for failing to remain silent about Vanderbilt's serious assault and battery in its hospitals that they failed to mitigate. So the question becomes, does that state put that at the discovery phase, make out what could Vanderbilt failure to mitigate that serious crime in its hospitals and conceal it from the public, constitute criminal negligence, constitute a violation of OSHA, or constitute any other civil or criminal code violation. We're not talking about at this stage what the plaintiffs talk to people about and how it ties in together. And where the court said be very careful at the motion to dismiss stage when only one sheet of paper has been filed to support the claim, that it not be used, the motion to dismiss not be used to challenge the strength of the plaintiff's proof. Has the plaintiff alleged in the complaint every element of the statute? And in this case, the elements are laid out under the whistleblower statute, and the only thing that's challenged is whether he has stated a claim or identified any illegal activity. And he has said that, and he has a good faith belief that Vanderbilt's failure to mitigate and his termination for reporting and not participating in the concealment of it was an illegal activity.
Where
And
would
that-
I find in the OSHA statute or regulations the steps for mitigation?
Well, I'm not sure, Your Honor, let me be responsive, but the violation of OSHA is failure to maintain a safe workplace that is, to the extent that it endangers the workers. So I'm not sure that it is necessary for it to be a violation of OSHA for them to fail to mitigate. It was the fact that they did not update the workplace violence policy that constituted a violation of OSHA. It was that they did not provide a safe workplace for the nurses who were getting battered perhaps by whatever the discovery shows, by the patients, the public, or vice versa, that violated OSHA because it was not a safe workplace. Just like if you went in and they didn't provide PPE for the current COVID.
What specific section of OSHA is violated?
The general duty clause, Your Honor.
The general duty,
That's
okay.
And the allegation also includes any and all other OSHA regulations that the proof bears out. And this is, like I said, and it clearly states in Webb that when you have a single sheet of paper at the beginning of a case, all you look for in terms of whether you can dismiss the complaint is whether the allegations of each element are that, in this case, they are.
Thank
Your
you.
Honor.
Thank you very much. Thanks to all of you. Mr. Clerk, would you sign us off?
The Honorable Court is now in recess.
Thank you.